Now, as to the motions for continuance and for change of venue. The purpose of a change of venue is to ensure that the defendant has a fair trial by an impartial jury. The same is true as the basis for the defense's latest motion to continue, with the hope that as time passes, people forget some of the pretrial publicity. Unfortunately, I think the pretrial publicity in this case will continue no matter how long we continue it. Perhaps some of it may, with time, be forgotten by people. And as far as change of venue, I do not think that that would give the defendant any kind of a fair trial beyond what we are doing here today. I don't think there's any place in the state of Minnesota that has not been subjected to extreme amounts of publicity on this case. Change of venue is an option in the rule when there is extensive pretrial publicity that is prejudicial, and there was prejudicial pretrial publicity, including the latest actions by the city of Minneapolis in settling the case. I'm not questioning whether they could or should settle the case at this time, but the bottom line is when it's reported by the press, it can affect the jury, it can prejudice or taint our jury pool. I'll be very honest, when that was first brought up by the defense, I thought they were overstating. I thought this really won't have an effect. People know it's a different case, different situation. I was a little shocked when we called back all the 9 jurors who had been seated, and 2 said it did move them off of being fair and impartial. We had all accepted them as fair and impartial jurors. 2 of them basically said that they could not be fair and impartial any longer. I was surprised that it had such an effect. That's probably a judicial bias. As a judge, I'm used to, okay, that's not relevant, so I'm just going to put it aside. So it is easy for me as a judge to disregard the fact that the city settled, knowing that it's totally different factors. But I have to remember that that's not the point of view that jurors are coming from. And so 2 said that they could no longer be fair and impartial. They were stricken. That left us 7. It is important to note that the other 7 did not feel that it was going to change their ability to be fair and impartial. Ultimately, on a motion to continue to ameliorate prejudicial pretrial publicity and continuance or change of venue for those purposes, is to find a fair and impartial jury. We have had 8 full days of voir dire from March 9th through March 18th, and now we're going to continue, hopefully, to select 2 more jurors. We had an initial jury pool of 326 from the random draw on February 1st, based on all the summons jurors who returned questionnaires. We have gone through 95 panel members as of March 18th. 57 have actually been questioned. 22 were excused for cause on the parties' joint motion based on the review of the questionnaires. 16 were excused from the panel by the jury office between February 1st and March 18th after having completed questionnaires due to postponements, ineligibility criteria, for example, no longer resident of Hennepin County, non-citizen, over the age of 70, health-related, etc., but prior to questioning. Of those 57 panel members whom we have actually questioned during the 8 days of voir dire, we have selected 12. Defense has exercised 12 peremptories. The state has exercised 6. And the court excused 27 for cause after individual questioning. I think it's worthy to note that I did give both sides extra peremptories. And people may wonder, how does that help? If I'm not going to change venue and I'm not going to continue the trial. There are jurors who are very clearly incapable of being fair and impartial. Some will come right out and admit it. Those are the easy ones. The court can excuse those when they say, for whatever reason, I cannot be fair and impartial. The next set are those who the court makes a finding that based on the totality of the circumstances cannot be fair and impartial. as I've said a few times during voir dire, just saying the magic words, they can be fair and impartial, does not end the court's inquiry. The court has to consider the totality of circumstances and decide if it has been established that they cannot be fair and impartial. There's a third class of jurors who don't say enough to establish a challenge for cause. Yet there are concerns that they still might harbor certain biases, and maybe it's rarely that they are lying to the court or to the parties. It's usually that they just have not done sufficient introspection, to be honest, and see how their biases affect them. It is for that reason that a peremptory challenge can be made if the parties believe that a person cannot be fair and impartial, that they would be biased against their client, be it the state of Minnesota or the defendant. That's the purpose of peremptory challenges. More were given after the settlement announcement because that would add an added layer of potential prejudicial pretrial publicity. And so to get at that third group, which might have grown in size because of their exposure to the settlement, that's the purpose of giving both sides additional peremptory challenges, to focus on that third group, which although they heard about the settlement, said they could be fair and impartial, but we all, or some, the striking party, had concerns that they could in fact be fair and impartial. And that's an appropriate exercise of peremptory challenges. Obviously, challenges based on race or gender, and that being the reason for the strike, are improper, and we've dealt with those on the various challenges that have been brought.